Welcome to today's program, Licensing Your IP. I'm Sean Wilkerson, Acting Community Engagement Office Director of the USPTO Northwest Frontier Community Engagement Office, and I'll be your MC and moderator for today's program. Before we begin, just a reminder, if for any reason you get disconnected during today's program, you can log back in using the WebEx link that brought you here. If you miss any portion of today's program, don't worry. We will be posting today's session recorded on our website in a few weeks. At this time, I'd like to ask our panel to introduce themselves, and I'll be starting with Gillian. If you can give us a brief introduction.
Thank you, Sean. Hi, everyone. My name is Gillian Fenton, and I am a patent and business development lawyer. So that means I do corporate work. And I have been supporting the biotechnology and biopharmaceutical industry for the entirety of my career, half of which has been spent in private practice in law firms in Boston, Massachusetts, and Washington, D.C., and the other half as in-house counsel for three prominent biotechnology companies, Biogen, Emergent BioSolutions, and GSK. I have also been a career-long member of the Licensing Executive Society of the United States and Canada, LES, and I'm a volunteer instructor in several LES courses currently. Thank you.
Thank you, Gillian. Bob, if we can have you introduce yourself.
I'm Bob Hill. I've been in the business of IP since around 1998. And I'm an attorney, I'm an electrical engineer. I've been in-house at a London-based broker and the IP operations for London. Was at Telecom, and in 2016 started my own intellectual property consulting business, doing anything from strategy work to brokering to expert witnessing, damages, valuations, and so forth. Also been a longtime member of LES, Canada, with Gillian, and as Gillian was also, as you failed to mention, in 2018, 2019, I was president and chairman of the board. Gillian was in 2021. And in 2024, LES Canada asked me to be the CEO in addition to running it. I'm also a member of the board of LES International. Karen over there.
Thank you. Brock, if we can have you introduce yourself.
Yeah, thanks, Sean. My name is Brock Lemires. I'm a professor of electrical and computer engineering at Montana State University. I've been here for 20 years. My research focus is building edge computers for operation in outer space, basically reliable computers or resilient computing. And about 5 years ago, I created a startup called Resilient Computing, which is a spin out of Montana State and has licensed some of the IP that was developed in my research lab. So I've had the experience of creating IP that was then licensed out, working through our tech transfer office. And I've also had experience on the other side of actually licensing IP from Montana State University and being the recipient of that. So kind of a unique experience. So I serve two roles, professor at Montana State and president of Resilient Computing.
All right. Well, while we wait for Casey, we'll go ahead and start. But once Casey comes on, we'll have him introduce himself. To start off our conversation, I want to start with Gillian and Bob. Since we have all levels of entrepreneurs here in the audience today, I want to ask you if you can tell us what is an IP license and how does it differ from selling IP directly?
Gillian, you want me to start?
Yeah, Bob, why don't you start and I'll follow up.
So, as Gillian also is, I serve as a longtime instructor for LES, teaching courses on all sorts of IP topics. And one of the things I like to say about the difference between a patent sale or an IP sale or a license, an IP sale is a one-off versus a license is a marriage. It's a long-term interaction between the licensor and licensee. And the interesting part about licensing is it's like a pie. You can slice it up into many, many slices. And you can slice it by geographic territory. You can slice it by licensed product. Many, many different ways you can license your IP.
All right. So I'll follow up on some of the topics Bob has just introduced. Um, a sale is a single point in time transaction, and it actually requires that the seller and the buyer agree on what's the value and what's the price to be paid for the asset that's being transferred, as opposed to a license agreement, which is more commonly used when it's hard to agree on a present day value, or the present day value really doesn't address the potential future value of a technology. So one case in point there would be when the Google algorithm was first developed, nobody knew even what to do with it. It was held to have, little to no value. And yet here we are when Google has become years later, one of the largest companies in the United States. That growth trajectory was built off the back of a licensing agreement between a startup and Stanford University. So that's an example. A license agreement is a way to create a lasting relationship between the licensor and the licensee, and also to align their interests, both of them, on the success of the technology they're licensing.
And one final key point is there's risks with both. When you do let's say, a sale or selling IP outright, you're agreeing to a value at that point in time. And that could be good for you as the seller because the value to the buyer may never realize. Or it could be only a percentage of what the buyer then reaps from buying that IP because they see a potential major future upside. So you have to look at it, from that point of view is, do you want to take a one-time payment or do you want to take maybe a payment up front and a royalty basis and what I call ride the pony and see how the licensee does?
Bob, can you maybe talk a little bit about what kinds of intellectual property are commonly transferred via license agreements, and what
Sure.
works best in different commercial situations?
So the first one, any form of IP can be licensed or sold. Patents, trademarks, trade secrets, copyrights, whatever you have it instantiated as. And that usually follows, from whatever you happen to have, whether it's a work of art, whether it's music, as a copyright, whether it's something that's been patented. So you can sell or license any of those. One difference I do want to call out is that if you exclusively license your trademarks, you as the owner still have the responsibility to manage the quality of the trademarks that the licensee is then using. Otherwise, you can risk losing that trademark. So you can't, in an exclusive license, all fields of use to one party, the licensor still has to retain that quality control. That's not the same with, patents and trademarks and trade secrets and so forth, and copyright. It's all depending upon the agreement you strike. You can license your, and it depends on the commercial situation that you want to enter into. Which works best? I hate to say this, I sound like an attorney, but it depends. It depends on what the licensee is interested in doing and what you as a licensor are willing to give up as far as your rights. Do you feel confident that licensee is going to be the right party to park, essentially, quote unquote, all of your rights or some of your rights with them? And that's where you have to make that determination is, hey, even if it was Google that said, hey, I want to take a license to your technology, that doesn't mean that they're not going to just license it and put it on the shelf. That's where you bring in, the expertise of people who have done a lot of licensing, and you build into the agreement benchmarks and other sorry, I was looking at one of the comments, and other things where you can measure the licensees actually doing what you wanted them to do. And I highly suggest you always build in those benchmarks.
I agree, Bob. In some countries, those are called diligence obligations, that the licensee has an obligation to advance and commercialize the technology. I'd like to quickly add that each of the types of IP rights, patents, copyrights, trademarks, and trade secrets, has a little bit different requirements for licensing. You've already touched on trademarks, so I won't belabor that one. But in each case, you can look at the statute that confers those rights. In the United States, for patents, for example, it's Title 35 US Code. And what that says is that in the absence of a license to a patent, certain activities are infringing and expose the person who does them to legal liability. And those can be to make, use, sell, offer for sale, or import whatever the patented subject matter is. Those categories are different for copyrights, and they're different again for trade secrets and trademarks. So each of these rights can be licensed together as a bundle, or you can carve them up and license some rights to one licensee and some rights to another licensee, which is a great way for licensors to diversify their portfolios and to make their revenue streams in the future more secure.
Thank you, Gillian.
Oh, sure. Welcome back, Sean.
Sorry about that. And Casey, are you able to join us now as well?
Yeah, I've been here. Can you hear me okay?
We
Yes,
can
sir.
hear you now. Sorry about that.
Okay.
So, Gillian and Bob, I wanted to follow up. What kinds of IP are commonly licensed, and which works best in different commercial situations?
Yeah, I'll go first on that.
Okay.
In the hard technologies, meaning, biopharmaceuticals, biologics in general, pharmaceuticals, chemistry, high tech, chips, and so forth, patents, which protect innovation, are a very, very frequent basis for licensing. Software may be more amenable to copyright. And for sure, in the humanities, books, articles, movies, for example, are all covered by copyright. So you might find copyright licenses more commonly there. A trademark is something that basically it's an IP right that's designed to protect the goodwill of your business. So it's fundamentally all about the domain of commerce. What are you selling? If you have a trademark right, people will associate your trademark with your business and therefore attribute goodwill to the quality and reputation of your goods. That's why, as Bob said a little while ago, it's important to include an audit, a quality audit and oversight there. So, if you have a long, and especially a long and regulated path to market, like we have in biopharma, you're probably looking at patents, as opposed to if you're talking about a consumer good or a new app or something like that, you may be talking more about a combination of trademark and copyright that may be more appropriate for the shorter development horizon and the shorter commercial lifetime.
And to add to that, one of the most common things we see licensed these days, as far as, let's just talk about patents and trade secrets, unless you've got a lot of patents, 20, 30, 100, companies are reticent to take a license. So you basically have to litigate. We're seeing more trade secrets being licensed than we are patents these days. Now, I can see that may change because as Sean has a new boss at the USPTO who is expressed more patent-friendly thoughts and actually practices. So patents are looking to become a stronger IP right. And as Gillian mentioned, they're an exclusionary right. A patent doesn't give you the right to do anything except exclude others from practicing what's in the claims of your patents. So, I get a lot of emails from people saying, hey, I just got this patent, or I have a patent pending. We'd like to license it out. And we turn them down most of the time because it's just a single patent. And it's very difficult to do that. Now, selling them, that's different, especially if we think it has value in the sense that we know somebody who would derive value from that in some manner. We could put a value proposition together.
Excellent. Thank you. Now, Casey, I want to turn it over to you because you work with the Tech Transfer Office at the university. Can you tell our viewers a little bit about what a Tech Transfer Office does and what kind of IP you're working with at the university level?
Yeah, in terms of the type of IP that we're working with, kind of like Gillian and Bob mentioned, it varies and it really depends on the class of technology and the market or the field that you're trying to license it into. But from a academic tech transfer perspective, you know, we really kind of follow the rules of the Bayh-Dole Act. You know, this is a piece of legislation that Gillian will speak to here in a little bit, but you know, tech transfer offices largely serve as, serve a role to secure patents for federally funded inventions and license them to private companies to ensure public benefit. So, you know, there's certain things that universities are good at. You know, licensing is one of those. There's other areas that, you know, universities aren't necessarily set up to support. You know, that would be things like, you know, manufacturing products, commercializing products, and, you know, those downstream things of an invention. And so when you're a new inventor, you know, for the folks in the audience, you know, some of these downstream activities like, you know, scaling manufacturing, navigating regulatory pathways, commercialization, or, you know, raising money to support, you know, product development. You know, universities aren't set up to do that. And if you're a new inventor, these activities might seem like they'll be straightforward, but, you know, I promise you, you know, they'll become immensely complex down the road once you get into them, and they're labor and capital intensive. And so licensing through tech transfer offices really allows universities to partner with organizations that already have or can develop expertise or capabilities. They have the infrastructure and the market access needed to bring products to market efficiently.
And what kind of products are you seeing through the universities?
Yeah, so my focus is, you know, my background is, you know, largely in, you know, biotech and biomedical, and that's kind of what my focus is here. You could probably lump engineering in with it as well. But, you know, those products that come from university inventions, you know, are generally, you know, from, you know, my experience, best protected with traditional like utility patents. You know, unlike something like, you know, software, which might be a better fit for trade secrets or copyrights. But, you know, patents are usually the primary licensing asset because they support, you know, in these fields like life sciences and engineering, because they support, you know, large time-consuming product development investments. And you also need them to, you know, justify your market positions that's needed to bring a product or platform to the market. So it varies, but, you know, I would say the verticals that I work with in life sciences, you know, kind of include, you know, therapeutics, diagnostics, digital health would fall in there, as well as medical devices.
Wonderful. Now, you mentioned the Bayh-Dole Act briefly, and this is for Casey, Gillian, or Bob, whoever wants to, or if all of you want to respond. Can you talk a little bit to the people watching about the Bayh-Dole Act and how that impacts licensing agreements and commercialization and what benefit it brings?
Sure, I'll go first. So at the end of World War II, the U.S. had made amazing strides in developing new technologies and actually deploying some of those technologies to help win the war. But now the war was over, and the government tasked a leader, Vannevar Bush, with developing a vision for what should be done with those technologies now that we were hoping to see a peace dividend coming from having made the investment in developing them. And he drafted a white paper called Science, the Endless Frontier. And that set the U.S. on a path to really valuing and continuing to invest in innovation and basic research after the war. That culminated in 1980 with the passage of the legislation that Casey referred to, the Bayh-Dole Act. What the Bayh-Dole Act did was it fixed the problem that the public was investing in R&D and not seeing much of a benefit from that because publicly owned patents owned by the U.S. government, were rarely licensed, and it was difficult to find a way to hand them off to the private sector to turn them into products that would find a market. The Bayh-Dole Act came about in order to devise a mechanism to make that happen. And it incentivized universities to patent their inventions and to enter into license agreements with startups and basically any company of any size in the private sector who was willing to take on the risk of product development and turn that technology that had been developed with taxpayer dollars into a product that could benefit the US public. And that has happened amazingly well over the last 45 years. So you have seen the US emerge as a leader in multiple fields based on that investment in basic R&D in academia primarily. And we've seen those strides happening across multiple industries, including my industry, biopharmaceuticals, Bob's, aerospace and defense, all the new technologies that Casey touches, and obviously also computing that Brock is familiar with. So it's a technology that has really turned, it's a legislation, excuse me, that has really turned the US into a global leader in innovation. And it's something that we should all very rightly be proud of having.
Yeah, it was a phenomenal piece of legislation. I'll just say for 1 minute and then I'm going to kick in here. You know, before Bayh-Dole, Birchby, and I forget Mr. Dole's first name off the top of my head. Bob Dole, yeah, mine. Put that legislation in effect in 1980. Less than 5% of university-created technologies ever made it to market, because the tax dollars that we spend that went to the government, that then went to the universities to fund them, the government owned the IP. Bayh-Dole turned that around and allowed the universities to own it. Therefore, significantly, hockey sticking the ability to monetize that IP. And the other thing it resulted in was around 1980, when the legislation came out, only 27 universities had tech transfer offices, and now there's more than 200, probably a lot more than that, because of the fact that it has created the pathway to monetize that IP that tax dollars created. It created the biotech industry, as Gillian said, and it really significantly bootstrapped aerospace, high tech, semi, and others.
Yeah, and I would just add to that too. I apologize I didn't get to make an introduction, but I'm with currently working with the Montana State Technology Transfer Office. But prior to joining this past January, I spent the last decade plus in leadership positions in biotech startups, and I can attest that Bayh-Dole and university tech transfer was still critical for our business success and innovation within these companies. In each of these companies, whether it was in licensing, out licensing, we always had some sort of connection to a local university that was in some way impactful for those activities, as well as the success of our business.
Thank you. That was quite the introduction to Bayh-Dole. That was really well done. Thank you. At this time, I want to kind of switch over to Brock and talk about Brock. As somebody with licensed IP, can you tell us about your experience and how your IP is being used, and what is the benefit for you as the creator and user of licensed IP?
Yeah, so I'll start with my first hat, which is the professor hat. So at MSU, Montana State, my research is focused on building space computers. So the IP was essentially an idea for how to recover from radiation strikes and continue operating. And it started a pretty small scale. And we received funding from NASA over the course of about 15 years, where we were able to mature the technology and do flight demonstrations. And we did everything. Small satellites, went to the space station 3 times. And last year, we actually did a successful demonstration on the surface of the moon. So about 7 years ago, started working with the Tech Transfer Office about what can we do with this IP? Is this something that other companies might be interested in? Could we license it out? And we started having conversations with small companies, large companies. And the larger companies kind of looked at the IP as it was a little too early on, right? So university research generally results in, a prototype and a paper. And it's not in a form that's ready to be mass produced and sold. So there's a significant amount of effort to get it into a box. And so a lot of the larger companies are like, it's just too early on. And so the IP at that time was know-how, or you could call it a trade secret, but it was not patented. It was just our secret recipe of how we build this computer. We talked to small companies and they didn't have enough infrastructure to actually take it to the finish line either. So it was kind of this IP that was really cool. It was getting a lot of funding from NASA, went to the moon. And so it was really cool, but it wasn't in a form that could be licensed. So then the Tech Transfer Office actually encouraged me as the professor to start a company and license it from the university. And that's allowed by Montana law. So I did it, and I licensed the know-how from Montana State University. And then as I started funding the company using SBIR funds, which is a Small Business Innovative Research Funds, which are grants from NASA, I was able to mature it a little bit on the company side. I hired some students and we got it into a form that was patentable. And so then we patented it with co-assignees of Montana State and my company, Resilient Computing. And then that became the license. So it started as a license for the know-how. And then once it was patented, it became a license for the patent. And the patent basically made it a lot easier to understand what it was. So then from the professor side, the reason that licensing it was really cool was because as a professor, when you do research, you never get it into the commercial market. You just end with a paper and a prototype, and then you throw it in the garbage and do it again. And it was always frustrating to me because I worked in industry before I became a professor. And I'm like, when do you actually give this to somebody and have them use it? So it was a mechanism for me as a professor to actually see the technology get put into a form that somebody could actually use and, benefit from all the research that NASA had funded at MSU. As the small business, what it really helped was licensing that IP gave us an advantage when we went after proposals. Because when you're a company that's 2 part-time people and one's a student, you don't have a track record. You don't have you don't look like you're sophisticated enough to do anything. But when you go, oh, no, wait a minute. We licensed an IP from Montana State University that's been funded by NASA and it's been de-risked, it's on the moon and all this sort of stuff. Then you actually look like you have something that's mature enough to build a business around. And so it was really cool seeing it from both sides. And one of the proudest moments for me as the professor and the business owner was we sold our first space computer in December of last year. So 6 months ago, we finally put it in a box and we had a big party and we, popped some champagne and then went over to UPS and we actually watched this thing be delivered to the person. And it was like a really cool thing. I was shocked at how much work it did take to take the university IP and actually get it into the box, because there's so many things you don't think of as an academic. But we did it, and we got it all the way to the finish line, and people are actually buying it now. So it's been very rewarding from both sides of the IP story.
Now, I want to ask a question because you mentioned something about working with the university, writing papers, throwing them away, starting over. How did you know not to disclose your information before reaching out to the Tech Transfer Office?
I didn't. Every professor is horrible at this. We disclose everything. Every conference, we tell everything, we publish everything. Professors are notorious for disclosing absolutely 100% of everything they do. At about 10 years where the Tech Transfer Office, 10 years ago, Tech Transfer Office started talking to me and said, you should probably start thinking about this as IP, not just a paper. And so they started kind of guiding me to maybe not talk as much, or the way that you publish is just slightly different. So you can publish the innovation and show test data without giving away the farm. So there's ways to talk about it and share the knowledge and, basically contribute to the body of work without giving away the secret sauce that makes it all possible. So they kind of guided me over the years. And then today I feel like maybe I only screw up 50% of the time, but at least 50% of the time I'm publishing the right way and we can preserve the IP.
And Casey, I'll put this question to you. How are you working with faculty to teach them not to disclose? And then after that, if you can talk about what metrics and milestones that the Tech Transfer Office uses to determine whether a license is worth pursuing.
Yeah. I mean, Brock, that was a great example. And, it's a challenge too, right? Because you always have new university faculty, you always have folks that are new to these processes. So education's an important part of what we do, right? Making sure that we're going around to the departments, talking about this process, how technology transfer can help protect inventions and inventors and, facilitate future licenses and startups like Brock's. But the one thing that, I think is important to communicate to new inventors and early stage inventors is that, from a academic standpoint, tech transfer offices can move rather quickly in terms of establishing initial protection, at least initial filings, I should say, whether that be for a patent or for a copyright. Getting a patent issued takes quite a while. But if you have an upcoming conference, or you're submitting a manuscript, or your manuscript is publishing, it might only take, in our case at Montana State University, it might only take a few days for us to kind of, submit an initial provisional patent filing, or to, give some advice on, what to disclose and what to avoid, depending on your translational aspirations. And so from a,
Go ahead.
in terms of evaluating new inventions and their licensability, again, this really depends on, is this going to be a traditional license? Who you license it to? There are a lot of variables, but I'll give you an example, and I'll give it from some time that I spent in industry with a diagnostic startup company in Michigan. And this company was a SPAC, so it was public, it was well capitalized, and our business model was really an in-licensing strategy where I came in to lead business development and technology scouting and due diligence. And the aim was to identify development stage human health diagnostics, so these diagnostics that were still being developed, for which our company could acquire a license to further develop and commercialize that technology in animal health as opposed to human health. So that was kind of the business model. So we had a number of licensing deals, some of which led to successful commercial products. But at the diligence stage, we needed to have a well-defined market need that we were looking to address. We were evaluating numerous technologies simultaneously that we could kind of pit against each other, and see how well that they address the market need as well as our company revenue and financial goals. So we were able to take kind of a quantitative approach to licensing decision making, where we developed in-depth scoring systems and weighting systems for various financial and product factors. But in order for us to be able to do this, I think what's important to communicate to this audience is that we had to first define what those, key drivers for our business were. What are the key metrics? What are the key milestones? We could then develop that scoring system or that evaluation system accordingly, but you can't really do that effectively if you don't have well-established company goals or, goals for your technology.
Great. And I'm going to add to that, and Gillian and Bob, you can join in on this question. How does someone balance granting enough rights to make the deal attractive while preserving future upside for the institution or the inventor?
I can start with that if you don't mind. So it all comes down to what I like to call the value proposition. There's a value proposition for the licensor who owns the IP, and there's a value proposition for the licensee. And you, as the institution or the licensor or the inventor, you've just created something, you've put a lot of investment and time into it, and you'd like to get some sort of deal out of that in the end that's good for you. Understanding it's got to be good for the licensee as well. So it's what I like to call weaving a value proposition. We start off when we go out and license and or selling IP with a value proposition to say, hey, Sean, we've looked into your company. We have these patents, these trade secrets, and maybe some software. You're doing these phones, but we think we can make it better. And let's start a discussion. And during those discussions, you find out what Sean's interested in, if he's interested at all, and selling him on why this is going to make his product better. And you start to get to the point of saying, okay, I really believe in Sean. I think, I'd feel comfortable licensing the following types of rights to Sean, you know, and maybe I start off and say, well, Sean's only based in the US, he's only selling in the US. I'm only going to offer him US rights to make, use, and sell, which is what a patent right is. And I'll allow him to sell only for phones when when this could be an amplifying device that could be used in other things. And then Sean comes back and says, well, obviously, we have on our roadmap and our strategy, we want to go into Europe. So you know what? We'd like to have Europe too. So it's a back and forth. Expect that. That, two parties entering into a license transaction, in my opinion, and anybody else can speak up, it very rarely ends with the deal terms that were set out in the beginning. Because it's a give and take, finding out information more from the licensee. They find out more what you have to offer, strengths and weaknesses, and in the end, you figure out I'm comfortable giving Sean rights in the U.S. and Europe, and let's say it's exclusive or non-exclusive, and I want this much money for that license, and I want these many royalties, and that all comes about from weaving this value proposition. What that also does is you can make a choice. You can license Sean all your rights if you wanted to and be done with it, and then depend on Sean to take your IP and make a great product like Brock did with his company, or maybe just part of the rights with Sean, and then maybe I go and I address Casey's company, say I'd like to give you these rights. So you're reducing your risk by parking them all with one person. But again, you don't really know that until you do a market study, put the value proposition together, and then start talking to the market.
So I'll address the question from the standpoint of what do you do if you're a startup, especially if you're a university spin out, and then maybe I'll toss it over to Brock to comment on that. If you're a startup or you're thinking of spinning out technology that you've been working on in an academic laboratory and becoming a startup, I would urge you to spend a lot of time thinking about what is that technology ultimately going to look like in its way down the road commercial embodiment? What is it that captures the economic value and appeal of that technology? And then think about what are all the parts that you're going to have to add on to what you already have in hand in order to take, some perhaps very basic technology and turn it into a product that someone will want to buy from you. And that should dictate not only your business strategy, but also your licensing strategy, because licenses are a way to access intellectual property rights and technology packages too, that were developed by other people without having to, kind of replicate all that effort and investment in developing them yourself. That's one of the primary values of licensing and an innovation economy that's built on licensing rights like this. So one of the other things, in addition to accessing rights, one of the other things that having a license and frankly having your own patent rights can also do for you is it helps a new company to attract investors. Why? Because having the IP rights demonstrates that you have secured a barrier to entry to protect your future product from competition. And having a license means that you had to engage in very detailed, very structured business discussions with a third party, whether that's a university tech transfer officer in the case of Casey, or whether it's somebody at a big company that you want to partner with, and you have survived a critical due diligence assessment of whether you are an economically viable and attractive partner to be granted that license. You can then turn around and show those assets to investors, and they will give investors more confidence that they should likewise give you money so that you can further advance development of your business and your technology.
Casey or Brock, do you want to add to that?
Yeah, I can. Just a comment on my specific case, which might be of interest, is when the license for my space computing technology was put in place, it was interesting because the tech transfer office described it as it's a line in the sand. So you're going to license today what you have, and then it's like, that's it, you draw a line. And then as a professor, you're going to continue working every day and advancing it, doing in the applied research realm. But then the business has this idea that it'll take what it got and convert that into a product. But that's not always the case either, because you might have to add things to it. So it's a line in the sand that continues to evolve on both sides. And as it matures on both sides, the university and the small business, it actually will take on different forms. And in some cases, the product or product line can evolve to a point where it actually isn't even using the original IP. And so that was a long discussion we had with the tech transfer office. And I thought that would be a sticking point. I'd be like, well, oh, what's going to happen if I start making a computer that doesn't use this? And they're like, that's business. That's normal. That's not the end of the world. You don't have to use this. And then what's another unique case with my situation is I started trying to fund the development of the technology at the small business using small business grants, so SBIR and STTR. And then I always had subcontracts back to Montana State. So it was coupled together, even though there was a license and a line in the sand, we cross-pollinated and funded more research at MSU that was coupled to the small business research, and it kind of went along. And so even though they're evolving, in my unique case, they're actually coupled together. And so it's almost like the IP is growing together organically. So again, it's unique when you have a university license, but just that evolution is kind of something I hadn't thought about as a professor.
Yeah, and not to belabor this too much more, but Brock brought up a good point there. I was with a company that was based off of foundational IP that we licensed from a university partner. But as we developed that IP portfolio, we in turn out-licensed some of that new IP that we created for fields and applications that we weren't going to pursue as a business. So, we were a cell therapy company. We had some IP that was relevant for a large biotools company that was interested in the viral surveillance space. And, we were able to carve out some licensing terms that was a kind of a win-win for both our companies that led to another product that made it to market that was commercialized by a partner, but it wasn't fully developed by our company.
And one final comment that I thought of when Brock was explaining the great interaction he had with Montana's TTO when they said that's normal tech development, business development, you end up not using what you originally licensed. That's brings into play key points that you always put into your licenses: milestones, performance milestones. I've inherited licenses when I've taken over jobs internally in companies like Lockheed and Telecom, where there were no milestones for performance. And there was the licensee wasn't performing, but there was no way to terminate the license. And therefore the license is stuck with an underperforming licensee. That's where you build in milestones in your agreement. That could be anything from milestones to raise money, milestones for product development, milestones for product launch, and it's some way to get your IP back if they become underperforming.
And moving on with that conversation, do you recommend, or how do you recommend handling IP that may be patent pending still during licensing talks? And what protections or disclosures are typical during that process?
So I'll start. Very often in the high tech and life sciences field, and probably many other fields, discussions around granting a license and even learning more about another party's intellectual property rights will start by entering into a confidentiality agreement, which is also sometimes called a non-disclosure agreement. And then the discussion may evolve through more, substantive business discussions. Maybe the parties start keeping track of what they've agreed and what are still open issues in a term sheet. And then maybe they'll eventually move on, if that is agreed at the term sheet level, to enter into a definitive license agreement. Now, the difference between the two is a term sheet is an informal and temporary negotiation support document. It can be 2 to 5 or so pages long, whereas the license agreement is a highly customized, fully developed legal agreement between 2 or more parties, and that can be 25 pages to well over 100 pages. So, you kind of need to work out major issues before you just delve into drafting something that's that complicated. Now, at least in the life sciences, people enter into IP licenses all the time while patents are still pending. And one of the reasons for that is that after 18 months after the original filing date, your patent applications are going to be published by the U.S. Patent Office unless you qualify for one of the very narrow exceptions that would allow you to opt out. So at some point, they're going to become known to the public, even though they're still pending. Once they're known to the public, you may no longer feel you need a CDA, but having one in place will always still protect business discussions that are hopefully ongoing at that point. There are different ways of structuring licenses so that you can include pending claims in them and even have a right to get some royalties from a product that is covered by pending claims, although you want those to be eventually superseded by granted claims in an issued U.S. patent. There's different structures for that. I won't go into the weeds. Bob, have you seen anything different?
So definitely enter into an NDA if you're getting into those discussions like that. They'll protect you, it protects them, makes everybody feel better. Mutual NDA. And as Gillian said, you could 18 months after you file a patent, unless you requested at filing non-publication, it will publish and everybody will know what's in your patent and what claims you're going after. So let's say you're entering discussions during pre-18 months, all right, where it's not public. Still get an NDA, still protects you. You'll have the ability to control what you share with them. There are multiple cases where I've been involved in license negotiations on behalf of a licensor, either it was my company or somebody else, where we stepped the type of data that we showed to the other side. And that can happen. It's not necessarily may not be a patent application, because patent applications around software are very speculative after the Alice versus CLS Bank 2016 Supreme Court ruling, but you can demonstrate, how your software works to a potential licensee, but not actually show them the source code. And, we've done that in the past. Say, we'll give you a compiled code, whatever version you want. They can play with it. The agreement that you do it under, it says they can't decompile, transfer, deconstruct, whatever. And then you enter in an agreement where you either transfer the source code to them if you feel comfortable, or you can put it into escrow with a company like Iron Mountain that says they're going to hold the source code in escrow in case I, as the licensor, go bankrupt, disappear, can't perform. You, as the licensee who paid a lot of money to get into the license, developed a product around it, you don't want to be left hanging. You can never get a copy of that source code. So that's another way you can balance out that risk of pre and post patent issuance when you're doing that. But yeah, you can license any form of a patent, whether it's pending, just filed, provisional. Keep in mind though, the earlier, is that a better word? If it's only a provisional filing, it has the least amount of value. If it's published, you may be able to ascribe more value. Obviously, an issued/allowed patent where you actually have claims that the patent office has said, these are the claims we give you, it has the most value.
So from your perspective, what are the most common mistakes inventors make when they first try to license their IP?
Well, I can start off with that. They try to do it by themselves, and they don't bring in a professional. And I'll say a professional from the point of view, Gillian is not your typical attorney. She's a transactional attorney. So I would suggest either you bring in a transactional attorney or someone like myself who's a business transaction person in IP, because the mistakes I've seen range from, not having milestones, and the licensee shelves your technology and never does anything with it, and you can't get it back. Or, there were no performance milestones as far as payments that were to be made that would then terminate the license. So your licensee never pays, but you can't terminate because there was no termination provision for non-payment. Those licenses are intricate instruments. As Gillian said, they can they can be upwards of 100 pages long with all the exhibits and everything else in them. So my suggestions for you is to bring in a professional to help you. Bring in the TTO office, folks like Casey with many years of experience, or people, if you're not in a university, you call up somebody who has many years doing this in the business, like Gillian and I. And I'm not promoting us, I'm just saying, look for people with those skills that are going to protect you. They're not just there to make a buck.
And that leads into our final question, really, which is where should someone begin if they want to license their IP? And where can they go to get more resources to learn about what to do and the right channels? And I think I'll let you answer that, but I will say people like yourself and Gillian, who are at LES and do education programming, that helps. But what are the other options? And Casey, I'll ask you to start with that one first, and then I'll move back over to Gillian.
Yeah, I mean, there's a lot of trade groups and LES among them that have a lot of great, educational material. Some other groups out there, obviously, Sean, USPTO, your educational programming. There's AUTM, which is kind of the Tech Transfer Trade Association for universities, as well as, small business funding mechanisms like SBIR and STTR that provide good resources for getting started. And I think, my advice for new inventors and very early or nascent companies, if you're thinking about licensing, I think the advice that I would give you would be very similar to probably what, Brock received when he was starting his company. And, that's, when you're making a pitch deck for a new business, make sure you're focusing on the business case, the value that you're going to deliver to the licensee. Don't spend too much time. What's most exciting to you a lot of times is the technical aspects of it, the novelty, how it's better than the competition. That's all very important, but make sure that you're kind of presenting the entire picture on those initial interactions or initial engagements.
Yeah, thanks, Casey. And I would like to turn around and give a shout out to Casey and University Tech Transfer offices across the country. This is their space. They do a lot to support innovation and to support out licenses and spin outs of new technology into startups. Just bear in mind, if you're on the startup side of those discussions, there's a little bit of an arm's length relationship that's starting to develop, because at some point you should be sitting across the business negotiating table from each other and negotiating, at arm's length on what your future business relationship is going to look like. But there's a lot of other stuff that will help you get to that point. A lot of universities and I think independent research organizations also run new business accelerators. And those are great organizations. They often bring in consultants who can provide pro bono or low bono advice to startups. Sean, unless you have a problem with it, I'm going to just type the name of a book in the chat. One of the most prominent people in my experience in licensing university-based intellectual property and using it to create an amazing innovation cluster is Lena Nelson. And now that she's retired from MIT, she's written up the best of her experience in a fantastic little book called Launching from the Lab, which if we have any entrepreneurs or future entrepreneurs on the line, I think this is, go out and get it. It's the best place you can start your research.
I'll put on my LES hat if you don't mind, Sean. I would encourage you to join a professional organization like LES or AUTM. AUTM is more university TTO focused, and I've been to many AUTM meetings. LES is more the industry focused, but there is a very large contingent of people that are in both. I say this all the time. LES has been the best investment in my IP career, because not only have I met people like Gillian and others at LES, you get to talk to them at the meetings. You get to find out, from their experiences. You get to listen to them speak. The one-on-one interactions at the coffee breaks or dinner, you get advice. People are just open and free to help you. Plus, LES has, as Sean mentioned in the beginning, we have out of the box 30-something educational courses. from basic beginners on up to advanced negotiations and things of that nature. But it's the community that both Autumn and LES offer that is very valuable for your understanding of what you're trying to do.
I would
And
like to
Brock?
just jump back in and add on to that, that if you're in this field, you're in one of the innovative industries, you have an interest in this subject matter, a professional society like LES or OFF be kind of a through line for your career, because I'm sure, you know, it's far more common these days than it was 20, 30 years ago that people will jump around in the course of their careers. Voluntarily or sometimes not. You know, how often are layoffs happening? How often are people having to start up their own businesses because it's a better and more secure path forward? A professional society can help you find your tribe, and they can support you through those transitions.
And Brock, any words of wisdom on your experience and resources you used?
Tech transfer office. I mean, mine was easy. I'm a professor. It's university IP, so you just go to the tech transfer office and listen to what they have to say.
Perfect. Well, I want to thank you all for your time today. I really appreciate you being here